Hello, my name is Eugenio Velasco Ibarra. I'm Associate Professor at the Department of Laws of the Instituto Tecnológico Autónomo de México. In this video, I will offer an account of the constitutionally significant actions that have been taken by the Mexican authorities in response to the current pandemic. I begin by noting that as of May 20th, according to the official figures of the federal government, there have been over 56,000 confirmed cases of COVID-19 and over 6,000 deaths attributed to this disease. In the Latin American context, these figures place Mexico behind Brazil and Peru with regard to confirmed cases, but only behind Brazil in terms of deaths. It must, however, be said that the relevance and accuracy of these numbers has been put into question due to low test rates and to the appearance of several reports pointing to a considerable undercount in the actual number of deaths. Although the first reported case of COVID-19 in Mexico was confirmed in late February, the first official measure taken by the federal government in response to the pandemic dates back to mid-March, when the Federal Ministry of Education issued a decree suspending all in-person educational activities across the country. From this moment onwards, the responses of the Mexican authorities to the pandemic can be divided into two broad categories. The first category concerns the actions that have been taken in order to mitigate the public health effects of the pandemic. Among these, unsurprisingly, are social distancing measures such as the suspension of non-essential economic activities. I should point out from the outset that the actions taken thus far under this first heading are not particularly noteworthy when compared to the more drastic measures adopted in other jurisdictions. The second category, on the other hand, concerns those actions which have taken place during the pandemic and which may be reasonably interpreted as responses to its adverse economic and social side effects, but which haven't necessarily been justified in these terms. This is the case, for instance, of the presidential decree which provides for the participation of the armed forces in law enforcement tasks. This, by the way, is arguably the most notable constitutional development of the past couple of months, and one which is likely to have a more durable impact on the constitutional landscape. I will discuss this decree more fully towards the end of this video. Back to the first category of measures, according to the Mexican Constitution, public health powers are a shared competence among federal and state authorities, with the precise scheme of distribution to be determined by the federal Congress in the National Health Law. Now, in case of public health emergencies, this statute explicitly centralizes all decision-making powers in the hands of the Federal Ministry of Health and grants it very broad powers, including the ability to regulate the free movement of people and to give orders to all other authorities at every level of government. However, this has not stopped state and municipal authorities from issuing their own regulations, some of which arguably overstep their powers. To mention just one example, while the federal government has only suggested but not mandated that people should stay at home, some local authorities have issued stay-at-home orders under threat of penalties. This example, I think, points to the possibility of future litigation arising from disagreements between different levels of government concerning the appropriate timing for restarting social and economic activities. Should these political disagreements find their way to the courtroom, they would come directly before the Supreme Court under the guise of a controversia constitucional, a procedural mechanism that over the last 25 years has served a pivotal role in safeguarding the federal constitutional arrangements which, before then, had traditionally been superseded by informal political understandings. Speaking of the federal judiciary, even though it has been operating on a skeleton crew since March, with some actions having already been taken towards restarting its activities by online means, there have been reports of some interesting cases making their way through the federal court system. Among these, the various amparo proceedings instituted by medical personnel against their working conditions in order to protect their own health seem particularly relevant. It is still too early to tell whether the federal judiciary will be called upon to play a large role in the defense of fundamental rights in this context, but the strengthening of its rights-protecting capabilities and the jurisprudential developments that have taken place over the last decade or so give reasons for being cautiously optimistic. The Federal Congress, on the contrary, has voluntarily taken on a minor role in this context by suspending its plenary sittings in both chambers since March, with one exemption in the case of the Senate, which on April 20th passed an amnesty law with a view to benefiting individuals accused or convicted of minor offenses. Although this statute was touted as an emergency measure to mitigate the spread of the disease among the prison population, the fact that its benefits can only be accrued on a case-by-case basis following a review by a commission that has yet to be set up by the executive means that its immediate application will not be possible. This passive, almost submissive attitude that the Federal Congress has assumed, especially given that the pandemic took hold during one of its ordinary sessions, which has now expired, is, I think, very concerning and a reminder of the lopsided nature of the separation of powers, which has always characterized, and it seems, is still a defining feature of the Mexican presidential system. Moving on to the second category of actions I mentioned above, I would just like to focus on two particularly important developments. First, the President submitted a legislative initiative to the Federal Congress which would allow the President to overhaul the budget approved by the lower chamber of Congress at his discretion in cases of economic emergencies. This is another development, should it be approved by the Federal Congress, that warrants some concern from a separation of powers perspective. Needless to say, this proposal was not well received by the opposition parties, and even the ruling party has proposed some changes to this initiative. Whether an extraordinary session of the Federal Congress is called in order to vote on this initiative remains to be seen. But it is a major issue which will certainly be considered in the near future. Finally, I wish to finish this overview of responses to the pandemic by recalling the presidential decree published on May 11th, which, as I mentioned before, provides for the participation of the armed forces in law enforcement tasks. This decree supposedly finds its constitutional grounding on last year's constitutional amendment creating a National Guard, which did allow for this possibility, but only following the guidelines mandated by the Inter-American Court of Human Rights in the case of Alvarado Espinosa and others versus Mexico. In that case, the Inter-American Court held that any participation of the armed forces in law enforcement activities had to be extraordinary, subordinated to civil authorities, complementary, regulated, and accountable to civil authorities. The decree, however, fails to meet all of these standards. First, it extends its duration until 2024 without giving any justification for this timeframe. Second, it does not subordinate or render the armed forces accountable to the civil authorities. And thirdly, the activities which the armed forces are allowed to perform are neither complementary nor regulated. The relevance of this decree cannot be overstated because it effectively institutionalizes and validates the law enforcement activities that the armed forces had until now, and for at least the last 15 years, undertaken in the shadow of the Constitution. The significance of this development will therefore, I'm sure, not go unnoticed by those familiar with the myriad of dire situations that many vulnerable groups across the country are facing. This brief overview of what I consider to be the most salient constitutional issues arising from the Mexican authorities' response to the pandemic thus far is, of course, by no means exhaustive. But nevertheless, I think it provides a systematic account that offers some insights into the strengths and weaknesses of the Mexican constitutional order. To restate a few important issues, first, the pandemic may exacerbate the tensions underlying the federal arrangements, especially those concerning the so-called fiscal pact that has become a contentious issue for some state governments. Secondly, the pandemic has evidenced the somewhat subordinate role that legislators appear to have interiorized, which raises some questions about what the current relationship between the legislative and the executive branches looks like in practice. And finally, the economic downturn and deepening inequality that will follow the pandemic might require judges to adopt a more decisive role in the protection of social and economic rights, especially given the lack of positive actions undertaken by the executive and the legislature on this front.